So good evening. As only one participant has joined, so I will be waiting for another 5 minutes, right? Kavisa, you have joined, but not others. So let's see for another 5 minutes, and we will be waiting to join others.
Okay, sir.
Right. Okay, well, good evening, ladies and gentlemen. In our last presentation, we discussed about the provisions of the Industrial Dispute Act, the structure of the Industrial Dispute Act, and how do we define an industrial dispute. This is important. Disputes means any dispute or difference between an employer and a workman, or connected with employment, unemployment, terms and of the employment, conditions of employment, termination of employment, of the service, or reinstatement of a restatement in service of any person for workman, right? So then we understood how do we, we studied or we understood what do we mean by workman according to, the definition stipulated in the Industrial Dispute Act, and the employer, because the dispute arises between employer and the workman. Okay. And then very importantly, we discuss the method of settling the dispute. There are a couple of ways to settle industrial dispute. One is by the commissioner, and the second by the minister, and there is another one by the labor tribunal, right? So how can Commissioner General of Labor intervene? Hello, do you hear me?
Yes, sir. We can hear you.
Okay. So these things we discuss, mechanisms for settlement of industrial dispute. Commissioner, sections 2 and 3. So these are the taking steps to settle the industrial dispute according to the existing agreement in the industry concern. Maybe a collective agreement. Endeavor to settle the industrial dispute by conciliation, or refer the industrial dispute to an authorized officer for. Number B is the most important one. By the commissioner, 99 of the cases are settled through conciliation. An endeavor to settle the industrial dispute by voluntary arbitration. Voluntary arbitration, I will let you know what do we mean by voluntary arbitration. In summary, this graph, this graphical presentation tells you everything, right? In one form, one slide. Commissioner, minister, and the LT means labor tribunal. Commissioner, by agreement, by conciliation, by voluntary arbitration, or even can refer for the authorized officer, but it never happened. Normally, Labor Department does not refer matter for outsiders. As appointing someone as authorized officer. No, it is not happening. But it is there in the act. But practically, it is not happening. These are the things. These are the mechanisms that are used by the Commissioner General of Labor to settle industrial dispute by the Department of Labor, and then the minister, compulsory arbitration, and the industrial court. In case of termination, person can go to LT, labor tribunal. And then we discuss this one as well, and the conciliation part. Right? What is the last note that you have taken? What is the last para?
So we stop from arbitration.
Sorry?
Last week we stopped from arbitration. Yeah.
This one, but we didn't discuss this one. Or discussed? Did we discuss this one?
Little bit we discussed about this part.
It is not clear, Nisansala, right? Has this already been discussed or not?
Little bit, sir.
Okay, right. Did you take note on voluntary arbitration and compulsory arbitration, the definition?
There's a small note, sir.
So read it out.
There are two types of arbitration, voluntary. First one voluntary, second one compulsory arbitration.
Hmm.
Voluntary arbitration means the referring of industrial dispute by the Commissioner General of Labor to an arbitrator to settle such dispute concerned through arbitration with the consent of parties involved to the dispute.
Right, good. That is enough, right? Then
Compulsory arbitration means referring to the industrial dispute to an arbitrator by the Minister of Labor to settle the matter through / by arbitration, notwithstanding the consent of parties to the industrial
so notwithstanding in, that is not the one word, not is one word and not withstanding. Nosalaka harimin, notwithstanding, withstanding. Right.
notwithstanding. Yes, sir.
Okay.
Sorry. Yeah, that's all.
Okay. And then there is another part. So voluntary arbitration can be a person, right, agreed by the parties, or if not, nominated by the Commissioner General of Labor. Okay. Terms of reference drawn up by the Commissioner General of Labor and arbitrator is limited to matter arising out of such reference. And the arbitrator can decide that the matter is not an industrial dispute, or is it industrial dispute? These are common, right? These under the voluntary arbitration, voluntary arbitrator can be a person agreed by the parties, right? Or if not, nominated by the CGL. Okay. Terms of preference drawn up by CGL, and the arbitrator must make all inquiries as may be considered necessary and must make an award that is just and equitable. So when matter is referred for arbitration, voluntary arbitration, the terms of reference drawn by the Commissioner General of Labor and arbitrator is limited to the matters arising out of such reference. එතනින් එහාට යන්න බෑ. Arbitrator can decide that the matter is not an industrial dispute. එයාට ඒක තීරණය කරන්නත් පුළුවන්. Arbitrator must make all inquiries as may be considered necessary and must make an award just and equitable. Award should be just and equitable, right? Okay, these are common actually, ladies and gentlemen, right? These are common. Okay, next bullet form. Voluntary arbitration, arbitrator, voluntary arbitrator. Can be a person agreed by the parties or if not, nominated by the Commissioner General of Labor. CGL means Commissioner General of Labor. Right. Even for the nominated person, nominated arbitrator, even for the nominated arbitrator by the commissioner, the parties to the dispute should give their consent. එකඟතාවය දෙන්න ඕනේ. Right. Next bullet form. Terms of reference. Terms of reference. Today, it's very few people, only 4, right? Maybe electricity board problem. But anyway, right, you can listen to my presentation. Terms of reference drawn up by CGL and arbitrator is limited to matters arising out of such reference. What does it mean? Arising out of such reference. The arbitrator should limit, the scope of the arbitrator is limited to the matters arising out of the reference made by the Commissioner General. Arbitrator cannot touch any other things. Only the matter stipulated, right, in the dispute, explained by the, it's a writing para, the para, the dispute is defined by the Commissioner General of Labor. Okay. Next bullet. Arbitrator can decide that the matter is not an industrial dispute. Not an industrial dispute. Arbitrator පුළුවන් ඒක industrial dispute එකක්ද නැද්ද කියලා තීරණය කරන්න. Right. Next bullet. Arbitrator must make all necessary inquiries Arbitrator must make all necessary inquiries. As may be considered necessary. As may be considered necessary. Let me explain in Sinhala as well. Arbitrator කෙනෙකුට dispute එක refer කරාම ඒ dispute එකෙන් එහාට යන්න බෑ. dispute එකට අදාළ කාරණය සම්බන්ධයෙන් සියලුම දේවල් inquiry කරන්න. right? අවශ්‍ය දේවල් නැත්නම් තව දේවල් ගෙන්න ගන්න. right? written submission ගන්න. right? අවශ්‍යයි කියලා හිතන ඕනෑම දෙයක් ඒ dispute එක සම්බන්ධයෙන් විතරයි අදාළ වෙන. right? inquiry කරන්න arbitratorට හැකියාව he must make all inquiries as may be considered necessary. අවශ්‍යයි හැඟෙන පරිදි. Next bullet. Next bullet. Arbitrator must make an award. Arbitrator must make an award. That is just and equitable. යුක්තිය සහ සාධාරණත්වය මත පදනම් වූ තීන්දුවක් ලබා දිය යුතුයි. Arbitrator. Okay. Then we will look at what are the relief. You know, once matter is industrial dispute is referred for an arbitrator, whether it's a voluntary arbitration or a compulsory arbitration, the arbitrator must, after having right inquire all related things, the arbitrator should give an award. That award should be sent to the Commissioner General of Labor. So when he is giving an award, that should be based on just an equity principle. යුක්තිය සහ සාධාරණත්වය මත පදනම් වූ තීන්දුවක් ප්‍රදානයක්. Award means ප්‍රදානයක් කළ යුතුයි. So through this award, what are the reliefs that can be awarded by an arbitrator? Right? Once the industrial dispute is referred for an arbitrator, whether it is a voluntary or compulsory, the arbitrator must inquire into and give an award based on just and equity principle. So through this award, there are reliefs that can be awarded by an arbitrator. මොනවද දෙන්න පුළුවන් සහන? Relief. Okay? Subtopic. Reliefs that can be awarded by an arbitrator. Relief that can be awarded by an arbitrator. Just give me 1 second. Right. So, subtopic, reliefs that can be awarded by an arbitrator. Relief that can be awarded by an arbitrator. The subtopic is reliefs that can be awarded by an arbitrator. Right. ලියන්න මේ විදියට. Once an industrial dispute is referred for an arbitrator, whether it is compulsory or voluntary, comma, the arbitrator must inquire into the dispute and give an award based on just an equity principle. යුක්තිය හා සාධාරණත්වය මත මූලධර්මය මත පදනම් වූ ප්‍රදානයක් කළ යුතුයි. In such an award, following reliefs සහන can be awarded, right? Simple A. Simple A. All wages and all other conditions all other conditions of service including for a period of strike or lockout. Strikes or lockout. So an arbitrator can award, right, all wages, back wages, right, or other terms and conditions of service. Say, for example, if a worker, if the matter is in relation to strike, the salaries or wages during the strike period. So it is up to the arbitrator. Remember that the award of an arbitrator can be challenged by the employer at a higher court. I mean, at the Court of Appeal. Sorry, yes, Court of Appeal. Okay, right. Simple B. Simple B. Reinstatement. නැවත සේවයේ පුනපත් කිරීම හෙවත් පිහිටුවීම. Reinstatement. Or discontinuance. Where termination is in dispute. Where termination is in dispute. Right. Simple C. Simple C. Simple C. Compensation. වන්දියක් නියම කරන්න පුළුවන්. Compensation. A gratuity. Within bracket, except error. Except if a gratuity is due. Under the Gratuity Act. It means that, say for example, dispute is termination of employment. The person can go to LT, but even can come to the Labor Department. It can be settled through arbitration. So then arbitrator can award compensation and gratuity, but that person is covered by the Gratuity Act. Arbitrator cannot be discussed or award anything related to gratuity. Arbitrator can award gratuity if that person is not covered by the Gratuity Act. Okay, right. That is what do we mean by except if a gratuity is due under the Gratuity Act. right? The gratuity covered by the Gratuity Act cannot be arbitrated, cannot be touched by an arbitrator. Never. Because that is separate act. It has to be dealt with that act. Okay, we close the bracket. If the gratuity is due under the Gratuity Act, except if a gratuity is due under the Gratuity Act, close the bracket. O bonus, OR bonus. O bonus. Right. Next, simple D. If an order for reinstatement, නැවත සේවයේ පිහිටුවීම නම් order එක. If an order for reinstatement is made, comma, if the workman requests, ඉල්ලා සිටිනවා නම්, requests, an alternative of compensation, an alternative of compensation. ඒ කියන්නේ නැවත සේවයේ වෙනුවට වන්දියක් ඉල්ලනවා නම් alternative of compensation. The arbitrator shall do so. Okay. Don't put, simple E, put a star mark, star mark or a dot, small dot, right? The award given by an arbitrator, the award given by an arbitrator, must be gazetted by the Commissioner General of Labor. Right. Next, star mark or small bullet. Award can be repudiated. අවලංගු කරන්න පුළුවන්. Repudiated. Award can be repudiated by giving notice of 3 months but repudiation shall not become effective until after 12 months from 12 months from the date of award, or expiration of notice. Right. Next, our subtopic, ladies and gentlemen, collective bargaining and collective agreements. I told you, the commissioner can settle industrial dispute, right? Through the provision of collective agreement, right? So, then what is the difference between collective agreement and collective bargaining? Collective bargaining is a process, ladies and gentlemen. It's a voluntary negotiation process between the workman and the employer, right? Without intervention of the government in relation to terms and conditions of employment. It's a continuous process, voluntary negotiation process. The end result of the collective bargaining, the voluntary negotiation process, the end result is the collective agreement. Okay? Collective agreement is an agreement between parties, workers and the employer, through the collective bargaining process in relation to terms and conditions of employment, which are applicable for a certain period of time. Okay? Do you understand? Collective bargaining is a voluntary negotiation process. The final result or outcome of the collective bargaining is the collective agreement. Finally, they sign an agreement for a certain period, maybe for a 2 to 3 years. Normally, it's a 2 years. 2 years period. These are the terms and conditions. Both parties agree. Then there is no dispute until the period is expired, because both parties have agreed on certain conditions, agreed to implement or agreed to from the worker side, right? They have agreed to give certain productivity, and from the employer side, they have agreed to they give the salary hikes, other benefits. So everything has been written in an agreement, in the agreement. Okay, do you understand? On the never. But anyway, subtopic, collective bargaining and collective agreement. Collective bargaining and collective agreement. Collective bargaining and collective agreement, right? Right. First para. Collective bargaining is the process of Kriyavali, process of voluntary negotiation. Voluntary negotiation. Voluntary negotiation between parties within bracket workers stroke unions, workers stroke union and workers stroke union and employer, close the bracket. With regard to wages and terms and conditions of employment, wages and terms and conditions of employment, conditions of employment without intervention, of the government. Right? So, an organization such as the Employers Federation of Ceylon may act as negotiator, facilitator, right? Government also can act as and facilitate, right? However, full stop. However, government can facilitate. However, government can facilitate the collective bargaining process. Next para. Collective agreement is the outcome of collective bargaining process whereby parties within bracket workers and employer employer just 1 second. Right. Whereby both parties, right, enter into an agreement which stipulates stipulates agreed terms and conditions of employment to be implemented for defined period, for defined අර්ථ දක්වන ලද for defined period within bracket normally for 2 years, right? Next para. Next para. Ladies and gentlemen, in order to make it legalize, right, make it legal, the collective agreement, I mean, it should be gazetted by the Commissioner General of Labor. Otherwise, if it is not gazetted, it does not have any legal power. Once it is gazetted, it has legality. No one supposed to violate, both workers, the trade union or the employer. Both parties are not supposed to violate the terms, conditions stipulated in the agreement for the agreed period, during the agreed period. Then it becomes the violation of law. Okay. Next para. A collective agreement must be registered. A collective agreement must be registered by the Commissioner of Labor by publication in the government gazette, in the government gazette, in the government gazette, to give legal effect, to give legal effect to give legal effect to the terms of such agreement, to the terms of to the terms of such agreement. Okay, ladies and gentlemen. So I think some participant, they may not be having electricity, right? That may be the reason. But however, I would like to have a small break, just maybe 5 minutes, right? Just to have some water, just 5 down, almost 9. So 9 up to 9:05, just 5 minutes. Remember? Okay, do you agree? No response from anybody, but anyway, just 5 minutes break, 5 minutes. We will be having another 5 minutes later. Right? Only 10 minutes break maximum, 2 times, 5 minutes for now almost 1 past 9. Okay, just 5 minutes break. Well, we start. Now our next topic is labor tribunal. This is the one mechanism that we can use to settle industrial dispute. Industrial dispute is difference or dispute between employer and workman or more workmen with regard to what? There are 6 points with regard to wages, terms of employment, conditions of employment. Let me, not pages, right? The employment, the non-employment, terms of employment, conditions of employment, termination of employment, and reinstatement employment, right? Whatever in relation to these things, the difference is defined as industrial dispute. So, how many mechanisms do we have? Mainly, how many mechanisms? 3 main mechanisms. One is settlement by the commission. Next one, settlement by the minister. Third one, settlement by the labor tribunals. Okay. Under the commissioner can settle it through the collective agreement if available. Or commissioner can refer that matter for authorized person. Or commissioner can undertake conciliation by the labor department, right? Through the labor department. That is the most, mostly used one. And the commissioner can refer that matter for voluntary arbitration as well. If all these mechanisms are failed, then the minister intervenes. Minister can refer this matter for arbitration, irrespective of the consent of the workers, right? Irrespective of the consent of the parties. Whether parties agree to refer that matter for arbitration or not, minister can refer. That is what we call compulsory arbitration. If matter is minor, but the matter is major, that is also a compulsory arbitration. But if matter is major, then minister refer it for industrial court. Industrial court. So what is the difference between industrial court and compulsory arbitration? There is no difference. Both can be defined or can be considered as compulsory. But the matter is minor. Minister can nominate somebody. There are pool of arbitrators. Minister can nominate somebody and refer the matter. If the matter is major, then industrial court has to be appointed. The minister select 5 people, not more than 5, right? Select people, arbitrators, and recommend to achieve the president to appoint them as judges to the industrial court. So, for 3 years, they are not being paid. If case is referred, then payment is made for the case, right? So, difference between the compulsory arbitration and the industrial court is both are same, but if matter is major, then arbitrators are selected from the industrial court. The judges appointed to the industrial court. The matter will be referred for them, maybe 2 or 3 or 1, right? Judges. That is also arbitration. Okay. Do you understand? Suresh?
Yes, sir, understood.
Right. So the third mechanism to settle industrial dispute is labor tribunal. Ladies and gentlemen, remember, labor tribunal can settle industrial dispute if such dispute is relating to termination of employment. There are disputes, for example, what you call promotion, right? Salary hikes, bonuses. Those cannot be referred. Those matters, disputes cannot be referred for labor tribunals. Labor tribunal deals only with the disputes relating to termination of employment. Okay, understand? Right. Take your note. A workman, first para, a workman, or a trade union, on behalf of a member, stroke members, of its union, comma, may, M-A-Y, may, make an application in writing likitav, to a labor tribunal
Sir, can you repeat it? In writing?
To a labor tribunal for relief or redress in respect of any of the following matters, right? I told you, labor tribunal can only deal with the matters, disputes relating to termination, but there are some other minor matters as well. That is the major one. Apart from that, if somebody, say for example, it's like this, right? The workers who are working in an establishment where no 15 workers are being employed, I mean less than 15 workers, then they are not covered by the Gratuity Act. They are not covered by the Gratuity Act. If someone feels that I need gratuity and he asks gratuity, and then from the employer say, no, you are not entitled for gratuity because I'm not employing 15 workers. So in such cases also, if he feels that, he can go to labor tribunal asking some gratuity or relief. Okay. Uh, uh, right. Number one, the termination of the service of a workman the termination of service of a workman by the employer. Full stop. In this case, full stop and continue. In this case,
Sir, can you repeat it, please? From the bottom.
from the so can you read the first one? The termination of work of service of a workman by his employer, right? Full stop, right? In this case, the worker who has been terminated, or relevant trade union union must make an application to the labor tribunal within 6 months, from the date of such termination. Right. So, number two, the question whether any gratuity or other benefits are due to him, are due to him, D-U-E, due to him. From his employer on termination of his service and the amount of such gratuity, the amount of such gratuity and the nature and extent, of any such benefits, within bracket, any such benefits, put a bracket. If matter is
If matter is
not covered by, you have to mute your microphone. Within bracket, if the matter is not covered by any particular legislation. If matter is not covered by any particular legislation. Close the bracket. What does it mean? Here it says that, you know, if there is a gratuity problem, you can go to labor tribunal. But gratuity, if the gratuity of that person is covered by the Gratuity Act, you can't go to labor tribunal for such matters. Right? For example, those who are working in companies where less than 15 workers are being employed, the workers in that company, they do not have gratuity under the Gratuity Act. Right? For example, you work in a company where only 10 people are working. Your employment will be terminated. And then you make an application to the labor tribunal, right? Questioning your termination. When you make an application, you can even ask some gratuity benefits as well, because gratuity matter is not covered by the Gratuity Act. Okay? Say, for example, on the other side, you are working in a company where 15 workers or more than 50, right? Workers are working. Then your employment is terminated. You make an application to the labor tribunal asking some relief. You can't ask gratuity from the labor tribunal. Why? Your gratuity matter is separate. It is covered by the Gratuity Act. Then the Labor Department has to take legal action against the employer based on the provisions of the Gratuity Act. So therefore, you are not supposed to, even though you mention, you know, in your application that you made to the labor tribunal in relation to termination, if you mention the gratuity, that will never discuss, because your gratuity matter is covered by some other legislation. Okay, but if you are working in a company where no 15 workers are being employed, then your gratuity matter is not covered by the Gratuity Act. So then you can ask many things from the labor tribunal. Okay? Understand? Is it clear or not? Number three.
Yes, sir.
Number three. Such other matters relating to the terms of employment right. Number three, such other matters relating to terms of employment, comma, ORO, conditions of employment, conditions of labor, conditions of labor of a workman, as may be prescribed, Now we are going to discuss the effect of the reference to the arbitration. The effect of the reference to the arbitration. What are the effects of referring industrial dispute to an arbitration? Section 41L says of the Act, Industrial Dispute Act, being an employer, right, commences, continues, or participates, being an employer, सेवा योजके क्वी सिटिमिन, commences, continues, or participate in or does any act in furtherance of a lockout in any industry after an industrial dispute in that industry has been referred for the settlement to an industrial court or for settlement by arbitration to an arbitrator, but before an award is respect of such dispute has been made. What does it mean? So let me read the second part as well. Being a workman, that is workman, being an employer, commences, continues, or participates in or does any act in furtherance of a lockout. What do you mean by lockout? You have not learned it yet because it will come under the industrial the trade union ordinance, right? Lockout means action taken by the employer. When you go to work, the employer has closed the gate. You are not supposed to enter. Not for ever, for some reason, say for example, some people are making some allegation, right, at workplaces. Suppose some group of workers are making allegations all the time. Then for 1 week, without informing, the company closed, the employer closed the business. Lockout means lock out the gate. You are not supposed to enter. The strike is undertaken by the workers. Lockout is undertaken by the employer. Okay, that is what we mean lockout. So once a matter is lockout also comes under the definition of industrial dispute, right? Non-employment, රැකියාව නොදීම. ඒ කියන්නේ රැකියාවට එන්න දෙන්නේ නැතුව ගේට්ටුව වහලා. That is what we mean non-employment. Right? Employment, non-employment, terms of employment, conditions of labor, termination and reinstatement. These are the sources of industrial dispute. Right? So lockout means non-employment. So if matter is once, what does it mean? This is nothing, ladies and gentlemen. Let me in simple way, right? If matter, if any, once industrial dispute is referred for an arbitration or industrial court, the employer is not supposed to do anything harmful to the workman or work. He must allow the workers to work and no harassment. That is what it means in simple way. Say strike, right? There is a strike. Then the matter minister will refer that matter for compulsory arbitration. Once matter is referred for arbitration, the employer cannot commence lockout, continue lockout. He should open the gate and allow workers to work. And the workers also, they should not continue the strike. They should go to work. They should maintain the discipline until the arbitration award is granted. That is what it means in simple way. Shall be guilty of an offense under this act. Okay? This is the legal jargon. You have to take your own note. Being an employer commences, continues, or participates in, or does any act in furtherance of a lockout in any industry after an industrial dispute in that industry has been referred for settlement to an industrial court or for settlement by arbitration to an arbitrator, but before an award is in respect of such dispute has been made, shall be guilty of an offense under this act. Second, being a workman commences, continues, or participates in, or does any act in furtherance of a strike. ආම්පුතානේ lockout කරන්න. සේවකයා මොකද කරන්නේ? Strike. In any industry, after an industrial dispute in that industry has been referred for settlement to an industrial court or for settlement by arbitration to an arbitrator, but before an award in respect of such dispute has been made, shall be guilty of an offense under this act. Okay? Is it clear now? Sujiva? යම්කිසි කාරණයක් කාර්මික ආරවුලක් බේරුම්කරුවෙකුට හෝ කාර්මික අධිකරණයකට යොමු කරාට පස්සේ තව දුරටත් අර හාම්පුතෙකුට සේවකයෝ වැඩට එන එක වළක්වන්න හෝ සේවකයන්ට හිරිහැර කරන්න හෝ බෑ. සේවකයොත් ස්ට්‍රයික් කර කර ඉන්න බෑ වහාම වැඩට යන්න ඕන මොකක් දෙනකන්ද අර ඉන්ඩස්ට්‍රියල් ඒ කියන්නේ ආබිට්‍රේට හරි කෝට් එකේ හරි ඩිසිෂන් එක දෙනතෙක්. එහෙම දෙනතෙක් තවදුරටත් ස්ට්‍රයික් කරන්න ගියොත් හාම්පුතා තවදුරටත් ගේට්ටු වහලා සේවකයන්ට හැරස් කරන්න ගියොත් එන්නේ නැතුනොත් ඒක shall be guilty and offense under this. ඒ කියන්නේ ඒක මෙම පනත යටතේ දඬුවම් ලැබිය හැකි වරදකි. පැහැදිලිද? right. then ඕගොල්ලෝම මේක ලියාගන්න. so I will give you time. yeah, do you see the presentation? Is it visible? The effect of the reference to the arbitration. Is it visible or not?
It is visible, sir.
Right. Then you take your own note. I'm giving 5 minutes, maybe. Yes. Once you finish, let me know. ඉවරුණ ගමන් කියන්න. හරිද? Have you done?
Yes, sir.
What about others? Angelina?
Yes, sir.
Right. So, there are a couple of points, right, that we have to mention. So, any relief or redress may be granted by labor tribunal to a workman upon an application made under subsection 1, notwithstanding anything to the contrary in any contract of service between him and his employer. In other words, LT can ignore contract and give some relief to the employee. What does it mean? When an industrial dispute is referred for labor tribunal presidents are not bound by the contract of employment. The labor tribunal president should look at the legal provisions, not the contract of employment or appointment letter. Whatever appointment letter says, he can ignore it and create some other relief, new benefits, but according to the law, labor law. Okay, any relief or redress may be granted by a labor tribunal to a workman upon an application made under subsection 1, notwithstanding anything to the contrary, contrary, to any, in any contract of service. Okay, right. First bullet. Then after that, you know, you have taken your own note, this one, and then after that, first bullet. Any relief or redress any relief or redress may be granted by a labor tribunal upon an application made under subsection 1. One is this one, here, and 2. 1, one is this one, here, the following one. 1, 2, right? Just make it like this. Right. 1, notwithstanding, right? This is the legal term, nosalaka harimi. Right. Notwithstanding. Anything to the contrary. Can ekinekata ගැටෙන පරස්පර. Contrary. In any contract of service, ඒ කියන්නේ සේවා ගිවිසුමක පරස්පරතාවයන් කුමක් සඳහන් වුවද ඒවා නොසලකා හරිමි. Contract of service between the workman and, he means workman, the workman and his stroke her employer, full stop. Employer, full stop. In other words, වෙනත් විදියකට කියන්නේ නම්, in other words, LT means labor tribunal, කම්කරු විනිශ්චය අධිකාරය. මේව දැකලා තියෙනවද?
ඔව් සර්.
කොහේද?
බොරැල්ල එක.
right. බොරැල්ලේ. එන්නම් පෙරලා මාවතේ බොරැල්ල පහු කරලා කොටා රෝඩ් එක පැත්තට යනකොට නේද?
ඔව් සර්.
right. ලංකාවේ labor tribunal කීයක් තියෙනවද? 37ක් තියෙනවා. මහේස්ත්‍රාත් අධිකරණ කීයක් තියෙනවද? 82ක් තියෙනවා මගේ මතකයේ හැටියට. right. labor tribunal වල ඇහෙන්නේ මොනවද? මොන කේස්ද?
The terminations වලට අදාළ ඒවා නේ sir.
අන්න හරි. ටර්මිනේෂන්ස් වලට අදාළ ඒවා විතරයි. හැබැයි අර ටර්මිනේෂන් ඇප්ලිකේෂන් එකත් එක්කම දැන් කෙනෙකුට හිතනවා නම් මට ග්‍රැටිවිටිත් ඕනයි කියලා. එයා හැබැයි ග්‍රැටිවිටි ඇක්ට් එකෙන් කවර් වෙන්නේ නැතුව තියෙන්න ඕනේ. එතකොට ඒවත් ඉල්ලන්න පුළුවන්. නමුත් මේන්ලි ටර්මිනේෂන්. දැන් ඒ නිසා LT වලට නඩු අඩුයි. තියෙන්නේ ටර්මිනේෂන් කේස් විතරයි. මහේස්ත්‍රාත් අධිකරණවල කම්කරු දෙපාර්තමේන්තුවේ නඩු 1600ක් තියෙනවා. ඒවට අවුරුදු ගණන් යනවා. දින දෙනවා. මේ නිසා අලුතෙන් පනතක් ගෙනාවා. කාර්මික ආරවුල් විශේෂ විධිවිධාන පනත කියලා. ඒ පනතෙන් බලය දුන්නා. කම්කරු විනිශ්චය සභාවලටත් මහේස්ත්‍රාත් අධිකරණ හා සමානව බලයක් දීලා EPF නඩු, gratuity නඩු, non-payment of wages, ඒ වගේ දේවල්, ඒ කියන්නේ terms අනිකුත් ව්‍යවස්ථාපිත ප්‍රතිපාදනයේ උල්ලංඝනය කරන නඩුත් මහේස්ත්‍රාත් අධිකරණ නැති බල ප්‍රදේශ තියෙනවල මහේස්ත්‍රාත් අධිකරණයකත් ඒවා නැති LT බල ප්‍රදේශ LT තියෙන තැන්වල LT වලටත් ඒ නඩු අහන්න පුළුවන් විදිහට LT වල අයට අතිරේක මැජිස්ට්‍රේට් කියන බලයක් එක්ක මේ බලය දුන්නා. දැන් ඉදිරියේදී EPF නඩුත් ඇහෙනවා LT වල. LT වල කලින් තිබිච්ච සාම්ප්‍රදායික කාර්යයට අමතරව in addition to the traditional task of the labor tribunal, that means hearing cases in relation to termination. Apart from that, now in future, very near future, now the other cases also will be heard at, such as EPF, non-payment of EPF gratuity, all these cases will be heard at the labor tribunal. Okay, this is for your, information. Vattala is there, Borella is there. I know because, sometimes I had to drop my daughter at labor tribunal, as lawyers is appearing always at labor tribunals. So his employer, in other words, take your note, in other words, LT can ignore the contract and give some relief to the employee. Right. Number one. One කියලා කිව්වර මේ උඩ අපි රිපර් කරපු එක. හරි. 1. The LT shall make all such inquiries into that application and hear all such evidence all such and here all such evidence as the tribunal may consider necessary, as the tribunal OLT may consider necessary, comma, and thereafter make such order as may appear, පෙනෙන විදියට, as may appear, to the tribunal to be just and equitable, just and equitable. Number 2, let me explain. This says, you know, LT is very specific court, right? Unlike other courts, the procedure can be decided by the LT. LT was established, the objective of the establishment of LT was to get an justice for an ordinary man who has been deprived. An ordinary man, he can go to LT and, you know, explain his case and get just an equity principle. But however, I mean, procedure is very, very type of informal. But unlike court, the policeman comes, you know, the salute and Usavian is Sabdavenu. Now, unfortunately, that was not expected. That was not expected from the labor tribunal. But now, LT also has become a court now. But that was not the purpose, right? Anyway, the act says, number 2, the procedure can be decided. The procedure can be decided by the LT. The procedure can be decided by the LT. Unlike, just give me 1 minute. So, the procedure can be decided by the LT, comma, unlike other courts that have to follow, unlike other courts that have to follow a very strict procedure, very strict procedure. Okay. Ladies and gentlemen, now look at this enforcement mechanism. This graphical presentation tells you or makes this graphical presentation, right, makes you understand easily how the enforcement mechanism operates. Okay, first look at dispute arises. Dispute in relation to employment, non-employment, terms of employment, conditions of labor, termination of employment, reinstatement of employment. Okay, anything related to that dispute, and settlement by the commission. There are number of, but mainly conciliation. If fails, commissioner fails, then the conciliation fails, then it refers to arbitration, either voluntary arbitration or compulsory arbitration by the minister. And the arbitrator gives an award, right? So then, if the employer do not compel, do not adhere to this award. If employer adhered, then from this point it is finished. But if the employer does not adhere, then the Labor Department filed the case in the magistrate court, by the commission, in order to implement this award. If award is not adhered by the employer, then the Labor Department, if not complied, then the Labor Department take legal action, filing case with the magistrate court in order to implement this award. At the magistrate court, on the conviction, fine will be imposed 5,000 rupees and imprisonment up to 1 year or both, in addition to the benefit, right? In addition to the benefit awarded by the arbitrator. He has to adhere to the arbitrated award, and also there may be a fine as well. However, if the employer is not satisfied with the award, if the employer is not satisfied with the arbitration award, then he has remedy. Employer has remedy. The employer can go to Court of Appeal by way of writ application. The writ, Court of Appeal, writ application, right? And then there is another position. If, say, for example, Court of Appeal also affirm the decision of the arbitrator, arbitration award, then if the employer is still not satisfied, he can go to the Supreme Court, what we call appeal to Supreme Court, Court of Appeal. Okay, right. Then once the Supreme Court is decided, then he has to adhere. In case if he does not adhere, the employer, then again, if not complied, again to the magistrate. In order to implement the decision of the Supreme Court, again we have to go to the magistrate court. This is the procedure, right? So, do you understand, ladies and gentlemen? Hello.
පාටිස් දෙකටම මේ විදිටමද මේ මැකනිසම එකේමද යන්න ඕනේ ත එම්පලෝය විතර
මේ හිතමු දැන් මෙහෙම employer විතරක් නෙමෙයි any party දැන් unsatisfied වෙනවනේ award එක අපි හිතමු මේ arbitrator award එක දෙනවා හාම්පුතාට වාසි වෙන්න, right? Assume that the award is granted, employer feels that it is, the award is biased towards the employer. එහෙම හිතෙන්න පුළුවන් worker. එතකොට worker මේ award එකට එරෙහිව writ application එකක් ගන්න පුළුවන් Court of Appeal. එතනින් පස්සේ leave to appeal එකක් කරන්න පුළුවන් Supreme Court වලට. දෙපැත්තටම. පැහැදිලිද?
Oh, sir. Thank you.
Right. Again, any party who is aggravated by the arbitration award, either party can, this is the procedure. But මෙතනින් එනකොට මේක එන්නේ award එක දෙන්නේ සේවකයාට, يعني හාම්පුතාට මොනවා හරි කරන්න කියලානේ. සේවකයානේ පැමිණිල්ල දාන්නේ. හාම්පුතා පැමිණිල්ල දාන්නේ නැහැ නේ LT එකේ. සේවය අවසන් කරා කියලා. කවුද සේවකයානේ දාන්නේ? ඒකට සේවකයා වෙනුවෙන් award එකක් දුන්නාම හාම්පුතා ඒකට ඇඩිය වුණේ නැත්තම් තමයි අපි මෙතෙන්ට යන්නේ. right? හාම්පුතා ඒ කියන්නේ ලේබර් ඩිපාර්ට්මන්ට් එක මැජිස්ට්‍රේට් කෝට් එකට යන්නේ. ඒ මේ award එක ක්‍රියාත්මක කරවන්න. හැබැයි මේ award එක දීලා නිශ්චිත කාලයක් තියෙනවා. ඒකේ ඇතුළත ඉක්මනින්ම එකෙන් අගතියටපත් වෙනවා නම් හාම්පුතාට හිතෙනවා නම් මේ award එක මට අවාසිදායකයි, මට සාධාරණව මේක දීලා නැහැ, just and equity principle අනුගමනය කළා නැහැ කියලා එයාට court of appeal යන්න පුළුවන්. සේවකයාටත් හිතෙනවා නම් මේ award එක මම බලාපොරොත්තු වෙච්ච award එක නෙවෙයි කියලා වැඩි සහනයක් බලාපොරොත්තු වෙන්නේ මේකට එරෙහිව court of appeal and supreme court යන්න පුළුවන්. හරිද? මෙතනින් එහාට කවුරුත් යන්නේ නැත්තම් award එක දුන්නාට පස්සේ සේවකයා යන්නෙත් නැහැ court of appeal, හාම්පුතා යන්නෙත් නැහැ. එහෙනම් මේක ක්‍රියාත්මක වෙන්න ඕනේ award එක. කවුද ක්‍රියාත්මක කරන්නේ? හාම්පුතා මේකට ඇඩ්ඩිය වෙලා දෙන්න කියන දේවල් දෙන්න ඕනේ. දුන්නේ නැත්නම් ඒක ක්‍රියාත්මක කරන්න labor department එක should file action against the employer with the magistrate court. Is it clear now?
Yes, sir.
Right. එහෙනම් ඕගොල්ලෝම මේක මට කියන්න බෑනේ. රූපසටහන ඕගොල්ලෝම අඳගන්න. හරිද? මෙතන තියෙන්නේ if else, මෙතන තියෙන්නේ if not complied, right? අනිත් ඒවා පේනවනේ enforcement mechanism. මේක කියන්න බෑනේ රූපසටහන මෙහෙම කොටුව කියලා. So you මම දැන් explain කරා. So මේක අඳගන්න මේ විදිහටම ඕගොල්ලෝ. As it is, huh? So let me have a cup of tea until then you finish.
So, excuse me.
Okay, Anna. Yes.
Sir, what is the involvement of labor tribunals in this mechanism?
Labor tribunal, there is no any involvement here. This is the enforcement mechanism of the Department of Labor. Enforcement mechanism, right? Department of Labor. Enforcement mechanism of the Department of Labor. Enforcement mechanism, right? Let me put this way. Department of Labor. Right? So LT, okay. LT also, Labor Tribunal also. This is, you know, the dispute arises. කොහෙටද එන්නේ? Labor Department. LT එකට යන්නේව නෙමෙයි මෙතන තියෙන්නේ. Right? LT එකට යන්නේ එකෙත් I will let you know once, you know, matter award is a decision is granted by the LT. If employer do not adhere to that decision, the Labor Department within 1 month, the employer can go to court of appeal, right? Against the LT decision. LT is separate. I will let you know that one. Here, the department, the mechanism. Okay. LT, the Labor Department does not have any direct involvement at the beginning with the LT cases. LT, anybody can go to LT in relation to termination of employment. Once LT decision is given, that decision must be imposed by the Labor Department. Okay. So decision is sent to the labor department. Once decision is given by the LT, that decision, copy of that decision is communicated to the Commissioner General of Labor. And then the Commissioner General waits, until 1 month, right? I mean, maybe 2-3 weeks. Once, right, 1 month, they will wait for 1 month because the employer has given chance to go to the Court of Appeal, not Court of Appeal, actually the Provincial High Court. Provincial High Court against the decision of the LT. Within 1 month from the date that the decision is given by the LT, within 1 month. And the compensation amount decided by the LT must be kept with the LT. And then they can go for the employer can go to the Provincial High Court. Okay. If within 1 month, employer does not approach to the Court of Provincial High Court, then the Labor Department, once 1 month is over, the Labor Department asks the particular LT, inform the Labor Department whether that person, the employer, has appealed to the Provincial High Court. If LT says no, then Labor Department file action against the employer with the magistrate court in order to implement the LT decision. Okay, is it clear now? That
Yes,
is
sir, it's
separate
clear.
one, right? I will let you know it later. This is the enforcement mechanism of the Department of Labor. Okay,
Okay, sir. Thank you.
right. මම හිතනවා පැහැදිලි ඇති කියලා හොඳටම. හරි. මේවා නැත්තම් ආයෙ කියන්නම්. Right. I know this A to Z. Each and everything. Okay. මේක ඇඳගන්න මේ විදියට. Diagram එක.
finish, sir.
What about others? Everybody? හැමෝම ඉවරද?
Yes, sir.
Okay. Now, because I will let you know this one, just 1 second. Collective agreement, settlement by arbitration, industrial court. This is, the labor tribunal, part 4. Application to the labor tribunal. So it says, what to do, right? Order of the labor tribunal and some court decisions, right? Enforcement order. If the employer fails to comply with the order, the commissioner may file a case against the employer under section 136 of Criminal Procedure Code Act number 15 of 1979. This is in relation to the enforcement of order given by the LT, Labor Tribunal, right? Suresh, පැහැදිලිද? ඒක ඉස්සරහදී
ඔව්
එනවා.
සර් පැහැදිලි.
හරි. මේ තියෙන්නේ Labor Department එකේ. හරි. Now, subtopic collective agreements, part 3. මම සරලව collective agreement එක විස්තර කරා. That is more than enough, but this is the legal, according to the act. This is the definition given in the act, Industrial Dispute Act. Collective agreements. Right. Forget about this section 5.1. You don't need to write all these sections. Right. According to this act, ladies and gentlemen, this act is wrong. When we are referring any legislation, the act A should be capital. Otherwise, kriyakarakam, action, right? In this act, collective agreement means an agreement A, which is between any employer or employers and any workman or trade unions or trade unions consisting of workmen, and B, which relates to the terms and conditions of employment of any workman or to the privileges, rights or duties of any employer or employers or any workman or any trade union or trade unions consisting of workmen, or to the manner of settlement of any industrial dispute. This is the definition. But in simple way, I have given you the simple definition, which is precisely, which is fairly correct. Fairly means fairly okay. This is the outcome of the collective bargaining process, whereby both parties enter into an agreement, employers and workers, in relation to terms and conditions of employment to be implemented within certain period of time. So this is the legal jargon, right? But you need to have both, right? So part collective agreement, put a dash, and part 3. So note එක ලියාගමු. According to the Industrial Dispute Act. According to the Industrial Dispute Act. According to the Industrial Dispute Act. Collective agreement means an agreement A, simple A. Agreement කියලා dash එකක් දාලා simple A. Simple A. Which is between any employer or employers and any employer or employers, comma, and any workmen or trade union workmen or any trade union or trade unions consisting of workmen and simple B, which relates to the terms and conditions of employment. Terms and conditions of employment of any workman, comma, or to the privileges, comma, rights, duties of any employer or employers or any workman or any trade union or trade unions consisting of workmen consisting of workmen or to the manner of settlement of any industrial dispute. Full stop. Any industrial dispute. We started according to the Industrial Dispute Act. Collective agreement means an agreement. Collective agreement. According to the Industrial Dispute Act, collective agreement means an agreement. A, which is between, and then B, right? The last one, you don't need to write it. Reference shall be made in collective agreement, Reference shall be made in the collective agreement to the parties and trade unions to which, and the employer and workman to whom the agreement relates. Reference then no, so you don't need to write it. So far, anything? Any question?
No, sir.
Okay. So what about others? Let me ask one by one. Sujiva. Are you in the class? ඔබ අවදියෙන්ද? ක්ලාස් එකේද? ලෙක්චර් එකේද? sorry. නෑ. ඔන් කරලා ගිහිල්ලා. නිසංසලා.
Yes, sir.
Okay, clear. Kavisha.
Yes, sir.
Dilhani, what about you? Right. Now, next topic is the effect of the collective agreement. The effect of the collective agreement. Collective agreement take effect ප්‍රතිඵලය මොකක්ද? So you don't need to write this section if you need, right? Put the section. Right. You know, the terms of the collective agreement, the terms stipulated in the agreement, shall be implied terms in the contract of employment. ඒ කියන්නේ ඔබගේ සේවා ගිවිසුමේ appointment letter එකේ මොනවා තිබ්බත් නැතත් මේ collective agreement එකේ සඳහන් වෙන ඒකෙන් ඔබ ආවරණය වෙනවා නම් ආවරණය වෙන සේවකයෙක් නම් ඒකේ තියෙන terms අනිවාර්යයෙන්ම ඔබේ සේවා ගිවිසුමේ කොන්දේසි බවට පත් වෙනවා. That is what it means. The terms of the collective agreement shall be implied terms in the contract of employment. Section 8.2 says, where there are any workmen in any industry who are bound by a collective agreement, the employer in that industry shall, unless there is a provision to the contrary in the agreement, observe in respect of all other workmen in that industry, terms and conditions of employment which are not less favorable than the terms and conditions set out in that agreement. මොකද මේ කියන්නේ? මොන employment contract එකේ මොනවා සඳහන් වුණත්, right? Unless there is provision to the contrary, where there are any workmen in any industry who are bound by a collective agreement. මේ collective agreement එකෙන් ආවරණය වෙන සේවකයෙක් ඉන්නවා නම් the employer in that industry shall observe මේ කැල්ල ව්‍යතිරේක කියන්නේ unless there is provision to the country in that agreement, right? So shall observe in respect of all other workmen. ඒකේ ඉන්න අනිකුත් සේවකයන්ටත් ඒ conditionsම දෙන්න ඕන කියන එක කියන්නේ, right? Respect of all other workmen in that industry, terms and conditions of employment which are not less favorable than the terms and conditions set out in that agreement. ඒකේ තියෙන ඒවට වඩා අඩු පහසුකම් දෙන්න බෑ. තමන්ගේ ඒ වැඩපල ඒකේ ඉන්න අනිත් සේවකයන්ට ඔක්කොටම සමාන වෙන්න ඕන. ප්‍රොවයිසෝ එකක් තියෙනවා. මොකක්ද? Any employer being a member of a trade union which is party to a collective agreement cannot repudiate the agreement independently, right? Any employer being a member of a trade union, any employer being a trade union which is a party to a collective agreement cannot repudiate the agreement independently. මේ trade union කෙනෙකුට මතක තියාගන්න employer ලටත් trade union තියෙනවා. ලංකාවේ හාම්පුතුන්ගේ trade union දෙකක් තියෙනවා. එකක් employer federation එක. අනිත් එක තමයි pre-trade zone manufacturers association. ඒ දෙකම trade union. හැබැයි හාම්පුතුන්ගේ trade union. Right? Employers also can establish trade union. Workers also can establish trade union. Right? කවුරු හරි දැන් උදාහරණයකට ගමුකෝ EFC, right? Any employer being a member of a trade union. අපි හිතමු දැන් trade union employer federation එකේ member කෙනෙක් මොකක් හරි hotel එකක් හරි කවුරු හරි මේ hotel එකේ වෙනුවෙන් employer federation එක collective agreement එකට enter වුණොත් අර employerට විතරක් තනියම මේ agreement එකෙන් අයින් වෙන්න බෑ, independently අයින් වෙන්න බෑ. ඒකයි මේ කියන්නේ proviso එක. Okay, right? So ladies and gentlemen, I'm not going to give you the note in this regard today because we have another 15 minutes. I would like to stop my presentation at this moment and see whether you have some other question to be raised. So remind me that. So let me make my own note. Otherwise, it's difficult, right? Right. From next day onwards, we have to start. Today, what is the lecture number today? පාරටෝකේ දෙනව නේද lecture number එක කීයද කියලා? කීවෙනි lecture එකද මේ?
9. So it's 9.
It's 9, yes. It's 9. So session number is 9. And we have to start from next day from slide number
20.
to be started from slide number 22. Sorry. Next day, right? Next day is, so what is this? ID Act up to slide 21. Right, up to slide 21, finish. Okay, now there is another 10-12 minutes. So any question so far? You have to remember this enforcement mechanism of the Department of Labor and the dispute, right? This one, particularly this is the commissioner mechanism for settlement of industrial dispute and the minister, labor tribunal part 4. What do we mean by these are the methods of and section 4 and section this is part 4A labor tribunal, right? This is method from the labor department and the minister. And how to define industrial dispute, how to define employer and employer. I remember, right? Even, I have prepared so far, yes, 4 question papers. And when I was looking at the answer papers, it's pathetic. Employer, right? Worker, right? At least, at least something. No, they have, most of the students, not most, some of the students, they have never referred for my presentation or to the video, right? Uploaded to the YouTube or whatever it is, right? By the LPEC. Some of them are very good. Some of them were very good. Around pass percentage is 80%. A 10 to 15%. A and A plus. Some of them are very good. Okay, anyway, any question? Very few students, participants today. වෙනද මේක මීට වඩා ඉන්නව නේද?
ඔව් සර් 16ක් විතර ඉන්නවා.
16ක් විතර ඉන්නවා. ඒක තමයි සමහරට කරන්ට් එකේ ප්‍රොබ්ලම්ද දන්නේ නැහැ.
සර් මේ සර් දැනට කරපු ක්ලාසස් වලට අදාළ ටියුස් ටික LPEC එකට යවලා සර් තින්නේ.
මේමයි මේ වීඩියෝ එක එහෙම් පිටින්ම දානවනේ මේකට. අප්ලෝඩ් වෙනවනේ. ඒ කියන්නේ ඔයා කියන්නේ ප්‍රසන්ටේෂන් ටික කියන එකද?
ඔව් සර්.
මට්ටෙන් එහෙම මේ දවස්වල නම් ඉල්ලන මට මේගොල්ලෝ කිව්ද මේක රෙකෝඩ් කරනවනේ. මේක රෙකෝඩ් කරාම මේ ප්‍රසන්ටේෂන් එකත් එක්කම වීඩියෝ ක්ලිප් එක යනවා. වීඩියෝ එක යනවා. ඔයාලට ඕනේ කියලා කියන්නේ ප්‍රසන්ටේෂන් එක වෙනමද?
ඔව් සර් අපිට ඒක තිබ්බනම් print outs ගන්න පුළුවන් සර්.
හරි. මං යවන්නම් මේක. හරි. මං මෙච්චර කාල කලින් කරපුවා යවලා තියෙන්නේ. නමුත් මං ආපහු සැරයක් මේ ටික ඔක්කොම එක සෙට් එකේ යවලා දාන්නම්. එතකොට හැමෝටම ආයේ මට හැම වෙලෙම යවන්න ඕනේ නැහැ. මං ඒක යවන්නම් ඒගොල්ලන්ට. මුකුත් නැත්තම් අපි නවත්තමුද? So others, if you do not have any question, so let me stop at this because only 4 students remaining. So then good night for everyone.
Good night sir.
Good night.